Well, good evening, everyone, to all of you in the room and those of you watching online, and welcome to our Law Commission Compulsory Purchase Consultation event. My name's Caroline Daly. I'm going to be your chair for this evening. We've got three excellent speakers, George Mackenzie, Hugh Flanagan and Richard Honey, KC. And before I pass over to them, I just want to say a few words and talk about some practicalities. So first of all, what we hope you might get out of this evening. Well, the consultation document is 359 pages long. The consultation is open until the end of this month, so perhaps at the end of this evening's proceedings, you might feel that you want to put in a response to the consultation. I know that we're delighted to have the Law Commission in attendance this evening. For those of you in the room, if you'd like to speak to them afterwards over a drink, I'm sure they'll stay around. I have an inkling that some attendees certainly know the consultation extremely well. Some of you may not have read all of it. Some of you may not have read any of it. So whatever your level of knowledge, we hope that by the end of this evening, you'll have a flavour of some of the more important or significant changes that are proposed in the consultation, and that you'll have heard the views from some members of the bar about the effect of those changes and perhaps the wisdom of them. In terms of practicalities, we've got 3 talks over the next hour or so. We'll take some questions at the end if there are any, but only in the room. We won't be taking any questions from virtual attendees, I'm afraid. So without further ado, I'll pass you over to George Mackenzie.
Thank you, Caroline. Caroline has very kindly given me the easy bit of the talk, which is just to outline some of the context and the background to the report. So it is for me to make a preliminary observation that in order that things can stay the same, everything must change. That's not a quotation from the law report's consultation, the Law Commission's report. I'm sure you'll all know it's one of the seminal lines from De Lampedusa's Leopard, which had its season premiere on Netflix last night. But there is a parallel. Which is this. In order for us to have a workable, fair, practical, modern, and ultimately useful code for compulsory purchase, both in terms of procedure and compensation, there is a lot that needs to change. And that is effectively what the Law Commission have done in their report. Those of you who have heard me speak before will know that I completely eschew long bullet points, and my slides are almost entirely devoid of content, but I hope that my talk will be otherwise. So the background, it's important to note that the consultation report that we're having a look at this evening is an early but very crucial part of a broader project of law modernisation. The goal of the process is for primary legislation to be drafted by the Law Commission and hopefully, certainly will be considered by Parliament, hopefully will be also enacted by the Parliament and by the King. I hope that, rewind a second. I'm sure that you're all aware that the Law Commission has dealt with the topic of compulsory purchase before, and I'll come to that in a moment. In terms of the terms of reference to the underlying the report, these were agreed by the Law Commission and the Ministry of Housing, Communities and Local Government in January 2023, shortly after, actually in the context of LURA being enacted. So at the same time that piecemeal reform was being brought forward, the minister decided that it was a good idea to reinitiate the programme that the Law Commission had dealt with some 20 years ago in order to produce a more comprehensive code. I've got a slide with the terms of reference. So the terms of reference are really important, and they're here. The terms of reference are to review the law, and that's the legislation, the case law, and the common law rules. I'm not sure, there's a notification has just popped up on my screen saying that people can't hear anything. I'm not sure whether. Anyway. No, yeah, sorry. Yeah. It's from the online space.
We just pause for a moment.
Sure. It's fine. Okay. Right. Okay. Good. I was told to talk into the microphone. So it's to review the law, all of it, the procedures governing compulsory purchase and the principles governing compensation. And so that's important. It's both procedure and the code of compensation. And it's to produce a draft bill or bills. So it's either one comprehensive bill or multiple bills in order to codify the law and make technical changes, ensuring that the law is modernized, simplified, accessible, technically sound, and internally consistent as necessary. And that's important because one of the points that the report makes is that it's not the goal of the Law Commission to propose kind of systemic and far-reaching substantive changes in the law. Obviously, there are updates, and we're going to hear lots about them, but it's not a kind of root and branch, radical, back to the drawing board and rethinking the notion of compulsory purchase. It's technical changes, modernization, codification. And it's also, number 3 here, is to review and consult stakeholders about compulsory purchase powers with a view to identifying anomalies and inconsistencies, etc. So that mandate has been digested by the good people at the Law Commission, many of whom are here today, and that gave rise to the production in December of last year of the report. The consultation is still, in fact, open, and the deadline for submitting consultation responses is the end of March, and I'm sure that the Law Commission won't mind me saying, as Caroline said as well, that they are really keen for people to engage and to provide and submit consultation responses. Obviously, when the consultation process is finished, the Law Commission will consider them, produce a final report, and at that point there will be lots more breakfast briefings and seminars here at Francis Taylor Building, no doubt. So why now? Why was the Law Commission asked to review compulsory purchase? Well, in summary, what the report says, and it's frankly hard to disagree with this, is that the field of practice and law for compulsory purchase is a unified area of law and practice in substance, certainly should be, but the legal framework is anything but. It's been described by a senior judge who is quoted in the report as being Byzantine in its complexity, and that is a statement which is undoubtedly correct and not just sensationalist. The bones of the law here are, as you all know, mid to late 19th century, but critical legislative flesh was put on the bones, and in fact, in many cases, additional skeletal structure was added in the 1960s and 80s, and in recent times there's been no less than 6 acts of primary legislation. So the idea really is to place the field of practice into a unified and cohesive legislative framework and to, as I've said earlier, amend, update, refresh, and generally modernize and render fit for purpose the law in substance and in form. All laudable objectives, of course. But I've said, as I said, this really should be regarded as a sort of deep retrofit and refurbishment of the structure of the law in this field, and not just a piece of or project of redecoration, but equally is certainly not a project of demolition and rebuilding. We've had a look at the terms of reference. Going to go back to that. The report identifies 4 broad heads of topic and addresses them. They are the general statutory powers to acquire land compulsorily, the procedure for authorising compulsory purchase, the procedure for implementing compulsory purchase, and then finally the assessment and payment of compensation. So that's what's in the report in terms of its scope. There are important carve-outs, what's out. Statutory blight notices are out. Alternative procedures for authorising compulsory purchase in the context of DCOs, Transport and Works Act orders and Hybrid Acts of Parliament, that's also out. And the Critchell Down rules are also out. There are two important things also to note. Firstly, as I've said before, the terms of reference are concerned with codification, simplification and modernisation. So it's technical reform, as I've said, not root and branch. That's the first point. The second point is it's noteworthy that the Law Commission's terms of reference do not include updating or reviewing or proposing new guidance. We've obviously had in the last few weeks new guidance issued, and new guidance will have to be redrafted undoubtedly in the event that primary legislation is put on the statute book, but the Law Commission are not dealing with the guidance. That will be a task for the Minister in future. So the scope of the consultation, all that I can hope to offer at this point before Hugh and Richard deal in more detail with some of their selected topics, is a bird's eye view. As Caroline indicated, it's over 300 pages and there are no less than 106 questions. The questions are effectively in two forms. Form one is where the Law Commission have formed a preliminary view about a topic and they ask for people's views as to whether that is a good idea. And the second type of question is information gathering, where they are have not yet reached a preliminary view and are seeking further information and suggestions. So I'm going to do a kind of whistle-stop tour and identify some of the areas that the report touches. As I've said, authorising compulsory purchase, consolidation of all of the enabling legislation, putting the compelling case in the public interest test on a statutory footing, removing the procedural distinctions between ministerial and non-ministerial CPO, the need for section certificates and special parliamentary procedure to be abolished, statutory challenge, not judicial review, for non-confirmation as well as confirmation, a single unified GVD-inspired procedure for implementing CPO, an extension of the untraced owner procedure to recalcitrant landowners or those without capacity. And then in terms of the compensation side, a move away from the single global figure approach to compensation, a proposal to allow parties to, by consent, adopt a before and after approach to injurious affection claims, codification of the principle of equivalence, clarification of the valuation date, particularly for severance and injurious affection claims, codification of the principles of equivalent reinstatement, and a clarification of situations where betterment is relevant and not relevant, codification of the Shun Fung principles for disturbance compensation and of the rule in Horn and Sutherland, and a codification of the duty to mitigate. That is, of course, just a sample. There are, as I said, more than 100 questions, and you'll hear lots more about some of them this evening. There were previous Law Commission reports, two of them, in fact. So this is the third. In July of 2000, the Department for Environment, Transport and the Regions had produced a report that described the law of compulsory purchase as an unwieldy and lumbering creature. So not much has changed, as I've indicated. The law report Law Commission report has quoted the judge who has described it in similar terms now. So it's the same problem 20 years later. The wholesale project of reform of compulsory purchase law, both procedure and in terms of compensation, was not adopted. Richard and I were talking about this earlier, and it's slightly unsatisfactory that it appears that the only reason why it wasn't taken forward is because it would have been a bit too much like hard work. That is certainly what the Law Commission consultation report indicates now. It was simply too difficult, and the need for reform was so great and deep that Parliament couldn't quite handle it. In terms of the way that the previous Law Commission reports are dealt with, it won't be a surprise to any of you who have read the two previous Law Commission reports, which are kind of encyclopedic in their calibre, that they loom large in the current Law Commission report. I'm going to deal very briefly with one topic of substance, that being the introduction. The topic that I've been asked to deal with by Caroline is question 54, section 4 of the Land Compensation Act 1961. And it's up here. It is a provisional proposal of the Law Commission to repeal without replacement section 4. We all know section 4, I'm sure. It introduces qualified one-way costs shifting. It's a provision which introduces a qualification because the mandatory effect of the legislation is engaged where one of two conditions is met. The first condition in section 4 is the sealed offer condition. So if an acquiring authority make a sealed offer that isn't beaten after a hearing, then the condition is met. And condition 2 is the dog's breakfast condition, really, which is that if a claimant makes a reference but has previously failed to state the nature of the interest in respect of compensation, or to give details of the compensation claimed, or to distinguish amounts under each head of compensation, or give details of how the amount has been calculated, then the condition is met. The provision is one way because whenever one of those conditions is met, then the tribunal usually has to order the claimant to bear not just their own costs, but also the costs of the acquiring authority from the date of the sealed offer or the date on which a properly particularized claim ought to have been made. And it is a shifting because generally speaking, the tribunal will order the acquiring authority to pay the claimant's costs of a reference. Section 4 is not wholly mandatory in effect. There is a carve out for special reasons if it thinks proper not to do so. The tribunal doesn't need to introduce that or enforce the qualified one-way cost shifting. What the Law Commission have proposed in the report is to repeal it without replacement, and what that would mean is that the upper tribunal, in the context of dealing with a reference, could make its own decision and exercise its own discretion as to costs. And the Law Commission's rationale for that is that that would be more aligned with the way that the tribunal operates in other cases, where it regulates its own procedure and has discretion in relation to costs. Frankly, my view is it's hard to disagree with what the Law Commission are proposing here, but equally it's hard to see that in substance the proposed change is going to make life any different, because where one of those two conditions currently in section 4 is met, it's difficult to see why the tribunal would not require a claimant to meet the acquiring authority's costs. A separate question is whether the tribunal's simplified procedure, where no costs will ordinarily be payable and each side will bear its own costs, is fair and just in circumstances where the only reason that a reference has to be made in the first place is because an emanation of the state has acquired land or rights belonging to someone else without their consent. Those are the points that I have been asked to cover. And on that note, I will pass you to Hugh. Okay. Good.
Thanks very much. Good evening, everybody. So I'm going to, after that bird's eye view, deal with some more granular matters on procedure, and Richard's going to look at compensation. And I'm going to pick up two of the most important, arguably, procedural reforms or consolidations proposed. The first relating to implementation of CPOs, and the second, a sort of partly related item relating to abortive CPOs. And on implementation, the proposal is to bring together the currently parallel and separate procedures of the notice to treat and general vesting declaration to implement a CPO. It is a undoubtedly striking feature of our system that we have these two quite separate processes, but achieving the same aim. It's one based on 19th century legal framework, one based on relatively modern legislation, 1981, the Vesting Declarations Act. It arguably reflects a sort of wider disconnect in the compulsory purchase framework, where you have a lot of historic legislation that's come forward in some form or other, and then on top of that there's another layer of modern legislation, and you have to try and understand them together. It's an obvious area which fits so extremely squarely within the Law Commission's terms of reference in terms of achieving clarity, simplicity, transparency, accessibility. At the moment, it's none of those things, really. And we're also an outlier, as I understand from the Law Commission's paper. We are, in terms of common law jurisdictions, it is now just England and Wales and Tasmania that retain a notice to treat procedure in addition to a vesting declaration procedure. So Law Commission has suggested it may be time to become a bit more mainstream. I think it's hard to disagree with that proposal. The real question is, how do you do it? And there are two options as per the slide. The first, a bold and radical approach, make it new, as I've suggested, as Ezra Pound put forward, reflecting George's literary theme. Alternatively, the approach is to base it on the general vesting declaration procedure, but retaining useful aspects of the notice to treat procedure. And understandably, the Law Commission have felt that the latter is more within their terms of reference, and that forms the basis for their proposal. And so what that looks like, the Law Commission have set out and tried to understand the reasons why the notice to treat procedure is still being used in addition to the simpler, more accessible general vesting declaration procedure. It is based on there isn't much by way of hard statistics, but it does appear that there is still, relatively common use of the notice to treat procedure, but it's, 10, 20% of CPOs it's used on by far the minority. But it is still being used for some specific reasons. So trying to understand why it's being used for those reasons, then incorporate the benefits of that regime into a unified procedure is the nature of the exercise. One of the major reasons why notice to treats are still used is when the acquiring authority only needs land temporarily. This isn't set out particularly clearly anywhere in guidance, certainly not in legislation, but it's from experience, my own experience, and certainly the Law Commission's research and wider practice, it is certainly a phenomenon. And essentially the way it works is that you serve a notice to treat and a notice of entry, but you then don't agree compensation with the landowner. So there's no obligation to complete the acquisition, and title is not transferred. And thereby possession can be temporary only, and you can not take the land and give it back if needed. And that contrasts with the essentially irreversible procedure under general vesting declarations, whereby you have the vesting date and it will then, you start the process and it will happen. There's no going back. So that's what's happening at the moment, and that the Law Commission have looked at how that might be incorporated into a unified procedure. And one of the main points they draw from that is that the fact that it's being used in this way really emphasises the need for some formal temporary possession power to be put on the statute books and brought into force, because of course we already have a temporary possession power on the statute books in the Neighbourhood Planning Act 2017, but it's not in force. Whether it needs to be that temporary possession power or some different version of it, there is, it seems, I think it's unarguable that there is some clear need for a formal temporary possession power. You have it, and it's very common now in development consent orders and Transport and Work Act orders to have such provisions. And just to, in terms of the obvious practical need for it, if you've got a road scheme which has construction compounds which you only need for 6 months for a year, why on earth should you need to acquire them compulsorily, permanently, and not be able to give them back by any formal procedure and have to either negotiate their return informally? So that's the essence of the issue. There's already an existing statutory solution to it, but I suppose this exercise gives an opportunity to decide whether it be that process, be that existing solution, or some further way to address the problem. The second reason for use of notices to treat that the Law Commission identify, which is a related one, and it's to do with when flexibility is needed over the extent of the land that's needed. So when the design of the scheme, again, take the road scheme example, has been worked up to an extent at the point at which you're seeking compulsory purchase powers, but there will be, as there often is, further design down the line, and that further refinement may impact on precisely how much land you need. And using a notice to treat to potentially take a slightly larger area of land initially, but then when you've worked out that actually you may need slightly less down the line, not to permanently acquire the full breadth of the land you've originally identified is a useful element of flexibility. And again, incorporating that into any unified procedure would seem to be desirable. Then three other ones they've identified. I think these are all potentially useful and helpful, but not quite in the same fundamental category as the flexibility in terms of land take and the temporal aspect of whether you need it permanently or not. But extending the time limit for implementing CPOs is a potential use of notices to treat at the moment, in that you could wait until the end of the 3-year period of a compulsory purchase order, serve a notice to treat, and then buy yourself another 3 years in which the notice to treat is valid, and not have to potentially go through with the acquisition afterwards if you don't serve a notice of entry and don't follow through with the acquisition. So a potential use of the notice to treat at the moment, the Law Commission query whether that may be an abuse of the notice to treat procedure, because the statute suggests you only should be serving notices to treat when you've decided you require the land, and therefore serving it on that sort of precautionary basis arguably is at odds with the statutory language. But in any event, it may be that formalising that procedure or formally enabling you to go beyond the 3 years of the validity of the order, provided that you then follow through with the purchase within a defined time after the end of the 3-year period of the order. Putting that on the statute book formally maybe improve clarity and transparency. The next one is being able to withdraw from purchase, in that notices to treat benefit from a specific statutory provision enabling you to withdraw the notice, it's subject to fairly tight constraints in section 31 of the 1961 Act. Essentially, I think it's on 6 weeks of receiving a properly formulated claim and or the tribunal determining compensation, provided that you haven't entered onto the land. But there is no such comparable procedure for general vesting declarations. It is a more irreversible procedure. And that, again, you can see incorporating that element of flexibility into a unified regime based on general vesting declarations would seem to be a useful, helpful and clear thing to be doing to enable authorities in some limited circumstances not to follow through on vesting if, for example, the compensation claim that comes in is simply at an unpredictably high level, which the authority could not have foreseen. Is it really fair that the authority then have to follow through with the purchase? And so then the final one is a more limited one, which is that NTTs can be used to acquire minor or expiring tenancies alongside a GVD for the superior interest, but that I think are less significant. So that essentially is the proposal to combine the two procedures. Would make a significant difference in terms of practice and procedure for those working in the area. It would create a new way to be implementing compulsory purchase orders, albeit based on existing legislation. And as I say, a very strong candidate for fulfilling the Commission's terms of reference. So that's that. Then second of two items on my list is abortive orders. And so this arises when an order has got past stage, whether it's submission for confirmation or confirmation, but the authority no longer wish to pursue it. And how that is dealt with formally is seen, the Law Commission suggests it might be an area which needs reform, clarification and formalising, because it lacks much by way of formal procedure at the moment. It's of some complexity because there are various, as I say, stages at which it can arise. So I take them in turn. The first one is before submission of the CPO to the confirming authority, assume the minister. There is no current statutory duty on an acquiring authority to submit a CPO for confirmation after it makes the CPO. There has been some discussion previously about whether a duty might exist, but the Law Commission in its 2004 report produced some, I think, fairly compelling legal analysis that it doesn't exist. There is a requirement to submit notices of making and to publish and to serve such notices, which talk about the order being about to be submitted, but it doesn't follow from that there's an actual duty to submit the order for confirmation. Well, the next question, if there's no duty to submit the order for confirmation, can the acquiring authority, despite having made the order, then somehow unmake it? And for lawyers, that will raise the question of whether the acquiring authority is in the legal Latin functus officio, as in they perform the function and they can't reverse it, in the same way that once you issue a planning permission, the local planning authority can't take that planning permission back, certainly not without paying compensation and revoking it. So the statute doesn't provide for this at the moment. It's silent on it, and it would potentially seem an area which could do with clarification. What happens to an order which the acquiring authority make, but then say because the funding falls through, they don't want to submit for confirmation? At the moment, the procedure seems to be that the confirming authority will essentially take it over and issue a non-confirmation letter, which for practical purposes puts it to bed, but it's not based on any specific procedure in law. So that's the first scenario. The second scenario is after submission but before confirmation. How can you withdraw a compulsory purchase order after you submitted to the confirming authority but before it's been confirmed? The Law Commission in 2004 and in its latest 2024 report have again suggested that the acquiring authority is here functus, they can't take it back, and that the confirming authority is seized of the issue, seized of the matter at this point and is in charge of it. And legally that analysis seems to be sound. And the question is whether there should be some ability for the acquiring authority to essentially withdraw the order despite the fact they've submitted it for confirmation. And then the third scenario is after confirmation, assuming it gets confirmed by the minister. On the same logic, it would seem that the acquiring authority have no power to formally withdraw a confirmed compulsory purchase order. It's out there, the minister's confirmed it, it exists. There's no statutory power to essentially take it away. It might not be acted upon, but given that its potentially draconian impacts, it might well be considered beneficial to have some process to formally withdraw it, tell the world it's of no effect, and enable people to proceed on the basis that it doesn't exist. So those are the scenarios. And in terms of the proposals for reform, the consultation paper asks this question on the slide. It says, should there be powers for the acquiring authority to withdraw an order set out in statute for the pre-submission period and or the post-confirmation up to service of a notice to treat, making of a general vesting declaration? So that assumes that after you've served a notice to treat or a general vesting declaration, or indeed a new combined procedure, you can't withdraw a CPO. You can see that for obvious reasons. It seems to me that while both of those, both 1 and 2, entirely understandable that you might have a power to withdraw, you might create a power to withdraw in those circumstances, it does beg the question of why would you not have a power also during the confirmation process to withdraw? The premise may be for that is because the confirming authority has taken over the process at that point, and it's no longer for the acquiring authority to withdraw an order that they've submitted for confirmation. If that is the logic, for my own part, I'm not entirely convinced by it. I mean, it seems to me that the practical reality is the acquiring authority are doing the acquiring, or going to be doing the acquiring. If they don't want to pursue the order, the order will not be implemented, and there is no point forcing the acquiring authority to, or not allowing the acquiring authority to withdraw their order, and having for it to go through the confirmation process despite the acquiring authority saying, well, we're no longer interested in this order, or more likely the funding has just fallen through. Homes England no longer will fund the project that underlies the order. And obviously the Secretary of State, the Minister, could, him or herself, having heard that argument, issue a non-confirmation letter. But it seems slightly inappropriate that the acquiring authority are not able to do that. I mean, you compare it to a development consent order, which could well contain compulsory acquisition powers. And if at any point the applicant for that development consent order decides that the project's not feasible, they don't want to pursue it, they withdraw the application. There's no requirement for them to continue and have a decision letter saying, no thanks. So that's the proposals about powers to withdraw. Then there's a separate question about deemed withdrawal. The Commission raised the suggestion that in certain circumstances, orders should be deemed withdrawn. And the first one, potentially the most significant one, is that it will be deemed withdrawn unless the acquiring authority submit it for confirmation within 6 weeks of making of the order. At the moment, no duty to submit for confirmation. So this would essentially create a duty to either submit it for confirmation, or it would lapse and fall away, would be deemed withdrawn. And it's quite a significant proposal, obviously in the interest of people not having CPO hanging over their heads. And that without there being certainty, there may be good reasons for it. But that's one of the proposals. The other ones, perhaps slightly more straightforward. If the confirming authority refuses to confirm, then it's deemed withdrawn, the Commission suggests. If the acquiring authority fails to serve a notice to treat or execute the GVD within the time limit, the Commission suggests it should be deemed withdrawn, or if a notice to treat lapses. And currently in the final two situations, the order would have lapsed because it wouldn't, the time limit for its implementation would have passed. But nonetheless, some formality and clarity that an order in those situations is of no effect, potentially beneficial. And then finally, just going to touch on one final matter before I hand over to Richard. What the Commission doesn't, this paper anyway, does not propose is perhaps one of the most significant issues raised by the previous 2004 report is, should there be compensation liability in the case of withdrawn or abortive orders? The 2004 report suggested that on withdrawal of a CPO or withdrawal from purchase, the acquiring authority should be liable for any loss or expense caused by the making of the CPO or the aborted purchase. The 2024 report considers that proposal is outside the scope of the terms of reference of the current paper, noting that, and I put the quote on the slide, that it may significantly expand compensation liability for acquiring authorities and should be left to government, who's better placed to conduct the relevant economic analysis and balance public and private interests. And I think it must be fair to say that it would be a very significant change, which on the terms of reference that George referred to, certainly arguably outside them. And there is also, and I'll just leave you with this, that the issue that the 2004 report was quite supportive of this proposal for compensation liability on withdrawal. But there's also the counter argument, and especially in the current climate when the government is trying to encourage the use of CPO, creating such a compensation liability would be giving rise to a liability for acquiring authorities, often local authorities with limited means, which would undoubtedly be at least some deterrent to CPO, particularly as CPO can fail for reasons which are entirely outside the control of the acquiring authority. For instance, if the local authority is reliant on funding from Homes England or central government funding, and that disappears, why should the acquiring authority then have to pay compensation for loss caused by a matter which was not, by a funding failure which was outside its control? If there are problems with, say, the blight regime, by which people are incur loss because of the threat of compulsory purchase, then fixing the blight regime may be the answer, rather than creating this quite significant new compensation liability. But as I say, that outside the scope of this paper, but an interesting matter anyway. And with that, I will hand over to Richard. Thank you.
Thank you, Hugh. So I'm going to talk about compensation, and I'm going to cover 5 particular topics. First, general principles, then Rule 2, Rule 6, Section 7, and Section 10 and Part 1 as the 5th topic. So generally, I think the Law Commission has done a good job in what it's putting forward, but I think there are some issues, which is probably good news for you because it'll make the talk slightly more interesting than if I was here just saying it's all fine. So first, general principles. Compensation as a single global figure. This was said to be an anachronism and the proposal is that compensation should no longer be regarded as a single global sum. When I first read that part of the report, it set alarm bells ringing in terms of, well, that's the basis on which you can't claim both for the redevelopment value of property and business disturbance as well. But there's then a separate proposal to codify also the principle that claims must be mutually consistent with the different heads, which is sensible. So my instinct is, generally speaking, not to suggest changes to things unless you really need to, because there may be unforeseen consequences. Even with many respondents to the consultation, we're not going to be able to predict everything. So as matters stand, I can't see why this would be a problem. But it also strikes me, frankly, that it's not necessary to do this. The problem, one problem at least, that could arise is then arguments that if it's no longer a single global sum, could you refer to the tribunal, for example, your Rule 2 claim first, and then a year later refer the Rule 6 claim? That seems to me that that would be problematic, and that there should still be a requirement, as it were, to refer the whole compensation claim to the tribunal at the same time, rather than doing it in parts. Principle of equivalence. There were two things the Commission considered. First, should they come up with a reformulation of it, a principle of fair compensation, and should it be codified? Seems to me that the Law Commission is right to recognise that there's not an overriding principle of, arising from the principle of equivalence. It's there to help statutory interpretation in unclear cases, but it is not there to allow claimants to claim more compensation than the law allows them to, or vice versa with acquiring authorities. They've taken the view, which I think is right, that a principle of fair compensation would be imprecise and vague, as well as being subjective, and also that if it was to be codified, they might be going beyond just preserving the status quo, which is part of it. So both of those, it seems to me to be right. We've got now, I think, helpful clarity from decisions recently from the Court of Appeal and the Supreme Court about what the principle of equivalence is, and there's no need to change that, no need to clarify it. Moving on then to Rule 2, there's a few proposals here. I'm not covering everything, just what seems to be the most notable parts of it. There's a change proposed so that compensation is going to be payable for interests as they existed at the valuation date, not at the date of a notice to treat, where a notice to treat is used. It seems to me that's probably a good idea. The procedure side of the changes obviously needs to ensure that they are being acquired, because you don't want to pay compensation for things that are not being acquired. But being able to take all the interests that exist at the valuation date and pay compensation for them as they then exist seems sensible. Raises the question in the consultation about the idea of land potentially having a negative value, and in those circumstances, compulsory purchase leading to a landowner having to pay the acquiring authority effectively for having the benefit of a liability removed from them. I don't think that's an issue, to be honest. In my experience, that's a non-issue. There's occasionally circumstances where an interest in land has no value, especially leases, but it's never been raised in my experience that someone who's having an interest in land taken from them should write the acquiring authority a check. It's interesting, I think, the way that it characterizes the changes on planning permission arising from LURA, because it recognizes that will lead to claimants receiving less than market value for the land that's been taken from them. That does seem to me to be a real issue. It's not within the scope of the Law Commission's report, and indeed it seems to me to be in contrast to the Law Commission's careful and balanced approach, but that's happening separately. So, third subject, Rule 6 compensation. Proposal to codify the Shun Feng requirements. It seems to me that that is okay in principle, but I am concerned about the duty to mitigate and how that's flagged, because it's put in the report as being that the loss must have been reasonably incurred. But I've included a quote on the slide from the Shun Feng case, which says if a reasonable person in the position of the claimant would have taken steps to eliminate or reduce a loss, or if a reasonable person in the position of the claimant would not have incurred a cost, then that is not recoverable. And it seems to me that that is a slightly more sophisticated approach. So it is not as simple, it seems to me, as saying that the loss must have been reasonably incurred. This is not necessarily going to be a real problem, because there'll need to be drafting in a bill that will actually cover this, but it does seem to me important that the drafting should try to reflect the nuance of what was actually said on this third rule in Shun Feng, rather than just costs must have been reasonably incurred. So there's a few points to mention under Rule 6. The second is changing the name to consequential loss. Fine, happy with that. The third is cutting off entitlement to recover costs and losses that were incurred before the notice of making the CPO. That does seem to me to raise a substantive issue, because why shouldn't a claimant be able to recover losses or costs that they can prove have been caused by the threat of a compulsory purchase order, perhaps recognizing the unfairness in that? There's an exception proposed that the tribunal can decide exceptionally it would be unfair to do it, or if the authority agrees. Now, of course, an authority is most unlikely to agree to pay extra compensation. They might do, but it's going to be hard to justify to their ratepayers. And if we leave it to the tribunal to decide, there's going to be a massive amount, it seems to be, of uncertainty and risk. You're going to fight for costs to be recovered under Rule 6, which the law says you're not entitled to unless you can make out an exception case. It seems to me that it would be much better just to rely on the test of causation. If losses have been caused by the threat of compulsory purchase, then they should be recovered, and then leave it for a case-by-case basis to consider that. Fourth point, pre-assessment losses to be valued at the date on which they are incurred. So obviously, when the tribunal, or if it's done by agreement, if you're assessing compensation, there will be future losses, in some cases at least, that you won't know exactly what they're going to be. But by that time, there will have been costs and losses that will actually be incurred. I think it's right that they should be taken to be, as it were, the amount that they were actually incurred and at the date that they were incurred. But I must admit to feeling slightly uncomfortable about the whole idea of talking about a valuation date for Rule 6 purposes, because there's no need for a valuation date for Rule 6 purposes. And when you're recovering losses in other fields like tort, for example, there's no need for a valuation date there. So whilst, as it were, I agree with the principle, those losses should be assessed at the time and in the amount that they're incurred, I don't think it needs to be called a valuation date. Fourth topic then, Section 7. There are 5 points that I wanted to flag. 2 of them, it seemed to me, have some issues with them. The first is codifying that Section 7 is only for diminution in the value of the interest in land. That reflects the position currently, but I suppose writing it up will give some certainty to that. Secondly, not to have a betterment deduction against Section 7 compensation. That seems to me fine. And when you're assessing Section 7 compensation, you take into account the kind of net effect of the scheme on the value of the retained land, both the pros and the cons of it, and it's only the net effect that you would take into account. So in that sense, some betterment is taken into account. The third point, and this is one that I do have issues with, is the proposal that Section 7 compensation can be based on a before and after valuation, so that you value the whole of the land holding before some is taken, and then value afterwards just the retained land, and the difference between the two is what you get. And the Law Commission doesn't say that's the way it's got to be done. It says it can be done if the parties agree or if the tribunal determines. So it seems to me the parties won't agree, because you're only going to be exploring this possibility if it would make a difference. Either the acquiring authority want it because they'll pay less, or the claimant wants it because they'll pay more. So they're not going to agree. And then the alternative, if the tribunal determines, it seems to me that that's problematic because it introduces uncertainty and risk. You've got to run effectively two different cases all the way through the tribunal with two different valuations. And you won't know what the right answer is until you get the tribunal's decision. So that will, it won't simplify things. Going back to the Commission's terms of reference, and it might lead to effectively the cost of those cases doubling because you've got to run two alternative proposals. Also, it seems to me that it won't work in many cases because of the difference in the rules between Rule 2 and Section 7. There will be, I mean, obviously kind of scheme disregards is different because Rule 2 valuation is done in the no scheme world, and Section 7 is done in the scheme world because it's the impact of the scheme that's being taken into account. But you've also got differences in planning assumptions and so on. But also, I would add that one of the things that comes out of the case law, including the Raymac case, for example, is that these are essentially separate exercises. You value the land taken under Rule 2 in isolation, and then you look at the retained land and value that without the scheme. So this would be an approach that it seems to me would be changing the entitlement to compensation, which risks at least going beyond the scope of the terms of reference. So the fourth of the 5 points under Section 7 is stating the valuation date is to be the same as the Rule 2 valuation date. That seems to me sensible and reflects current practice. The fifth point, which also seems to me to be problematic, is asking about whether post-valuation date evidence can be taken into account. And the report mentions conflict between different lines of authority, but I'm not sure there is a conflict because I think there are two different things that it's necessary to consider, and I'm not sure the consultation actually draws this out. So the first thing is the damage. You need to work out what damage the scheme has done, and this is partly the debate we were having in the Elitestone case, because you've got to have regard to the damage sustained due to the exercise of the powers confirmed. And it seems to me that when you ascertain the damage that has been done by the exercise of the powers conferred, you judge that based on what has actually been done. By the time you're assessing it, some of the damage might have to be predicted because it's in the future, but some of it will actually have been incurred. The damage will have crystallized by the time you get to assessment. So it seems to me that when you work out what is the damage that's been done, that should be based on the best information available, which is what has actually happened up to that point in time. And then there is the second separate exercise of ascertaining the diminution in value caused by that damage, which is a valuation exercise, and that shouldn't be done by regard to post-valuation date evidence, because that needs to be done as matters stood as at the valuation date. So it seems to me that there are these kind of two separate stages. One is to define the damage, and then secondly, to assess the diminution in value to the interest in land caused by that damage. And in that second part of it, that's when you shouldn't have regard to post-valuation date evidence. Fifth topic, final substantive topic, is compensation where no land is taken, and this is section 10 and part 1. The proposal is to amalgamate the two things into one complete unified single code for depreciation caused by public works. It seems to me that this is challenging because the two things are really quite different. So it will be quite a task, it seems to me, to try to amalgamate those two different regimes while also staying within the scope of the terms of reference. And it seems to me it is hard to see how this can be done in a way that doesn't change the entitlement to compensation. It's also potentially going to be problematic because, as we've seen from decided cases, but also some that have settled and not got to the tribunal, in recent years at least, that part 1 regime has been subject to a kind of ambulance chasing group litigation approach. So if we're going to rewrite the law to create a new entitlement to compensation for depreciation caused by public works, then it's possible at least to see the new regime being open to the same kind of approach that we've seen to part 1 claims in recent years. So other elements of this, it really seems to me as an approach, the Law Commission is seeking to change as little as is necessary. So I've set out there a number of the things that are proposed to be retained, which it seems to me is right if you're seeking not to change the balance of compensation. But as I say, it really does seem to me to be a difficult task, and whether it's going to work is going to depend, I think, on the detailed drafting of it. If it was up to me, I'm not sure it's worth the bother, to be honest, of doing it to get it right. Conclusions. I'm afraid my conclusion slide has disappeared, so this will definitely be a surprise to you. So I do think, one conclusion, there's definitely, as a result of the proposals as they stand, going to be some changes to compensation in some cases at least. It's unclear how many cases and how big those changes are going to be, but you can't change the rules to compensation without changing the results that they're going to have in some cases. I think it's also the case that there's going to be a lot depending on the detailed drafting, which we haven't seen. I've mentioned things like the Rule 6 duty to mitigate, consideration of post-valuation date information I've mentioned, and also the amalgamation of Section 10 and Part 1. Beyond that, there's a number of things where the tribunal is going to have discretion to do different things. So compensation under Rule 6 for pre-notice losses, I've mentioned the Section 7 before and after valuation, which it seems to me would in one sense be best avoided because it's just going to create uncertainty. Decide what the rule should be and stick to it. So generally a sensible set of proposals overall, but a number of things that seem to me are going to need to be worked through. So I just want to finish on a personal note because the Law Commission was generous enough to describe the book that I edit along with Caroline, James Pereira and Rebecca Clutton as a leading textbook. And I'm pleased to be able to say that we've got a new 5th edition coming out in June, where we're going to be able to cover the Law Commission's proposals. And indeed, it seems to me likely that that edition is going to remain valid for some time, because whatever changes come will take some years to work through. But I'm afraid I'm not looking forward to having to rewrite the book when we get to 2028 for the 6th edition. Thank you.
Thank you very much, Richard, and thank you to all the speakers for a very helpful distillation of the Law Commission's report. And as chair, thank you very much for all keeping to your time limits. We've got a few minutes for any questions from anyone in the room. Nope, no questions. Very good. Well, thank you very much all for coming. You're all in the room very welcome to stay for a drink next door, and I look forward to speaking to some of you there. Thanks again.